This listener says, my cousin fell in a store in another state, sued, and besides her medical expenses, was able to collect her lost wages and something for pain and suffering. I fell in a store here in Georgia, she says, and injured my ankle. I was able to collect some medical expenses, but nothing else. And here's the kicker. I thought that laws in the United States were the same across states. Why the difference in laws?
Well, of course, injury law is basically governed by state law. We do have a federal system, and the laws are similar from one state to another, but there are some variations, and probably in some states there are some requirements, some procedures that make it a little bit more difficult to prevail in a case like that. But I do want to say that you can certainly recover damages in Georgia for pain and suffering, for lost wages, as well as medical expenses. So it is not correct to say that we don't have the right to do that here, just as you do in other states. You do have to be able to establish that the store was at fault. Now, what might be going on here, and I'm drawing some inferences here, many businesses have, as a matter of customer goodwill, medical payment insurance. It's not required by law, but many businesses opt to have that coverage, which means that if someone is injured on the premises, regardless if the customer was at fault or whether the store was at fault, as long as they're injured on the premises, they will provide medical coverage up to a certain limit, which varies from policy to policy, typically about $5,000, but sometimes more, sometimes less, and sometimes that they opt not to have it at all. So it could be that this listener may have been provided with medical payment insurance by the place where she was injured, and that may be, and of course under that, only thing you can recover is the medical bills. But she would still have had the option of bringing a lawsuit and suing for pain and suffering and lost wages, just as you can in other types of injury cases, automobile accidents or anything else. All of that can be recovered, but you do have to prove that the store that they were at fault in some way, either that they knew that the hazard was on the floor, or that they failed to inspect to make sure
in a timely
manner to remove anything that was there. So you can have a situation where somebody is walking down an aisle and they turn into the next shopping aisle and they fall on some water, liquid on the floor. And obviously that customer was hurt and it wasn't their fault, but they may or may not be able to recover against the store. It depends on a lot of factors, because it could be another customer may have spilled some water or something just 15 seconds before, and the store can't inspect every 15 seconds.
Sure.
So in that type of situation, the store would not be liable for those damages. But if it turns out that that spill had been on the floor for, say, hours, and the store either ignored it or just didn't inspect, then if you can establish that, then you can recover all the damage.